Good morning, everybody. Thank you for joining us for today's webinar. My name is Amber Hines, and I'm the owner of Ashbur. We specialize in Medicaid compliant annuities from A-rated insurance carriers, as well as hybrid long-term care insurance policies. If you have any questions during today's webinar, feel free to type those into the questions tab of the GoToWebinar dashboard. And also, we're planning on leaving about 15 or 20 minutes at the end of today's webinar to answer those questions. So we're really excited about having Todd Watley here with us. Todd is a certified elder law attorney with over 20 years of experience doing elder law planning and Medicaid planning. Today, he's going to be talking about the basics of Medicaid planning, how that is important to your practice. So this should be beneficial to any attorney that is just getting into doing elder law or is currently doing estate planning. So I'm going to turn things over to Todd now, and thank you again for joining us.
All right, thanks, Amber. I appreciate this opportunity, and you know me well enough to know that oh, what just happened?
If you click back on the, oh, there it is.
Okay, good. Okay, so thank you very much. You know I love Medicaid planning, I love elder law, and I appreciate this opportunity. So like you said, today's presentation is the basics of Medicaid planning, and I came up with this subtitle just because it's true, but you know, some people are like, oh my Lord, how do we do this? There's so many options. And so hopefully the purpose of today is to let you see this is really not that hard. It is complicated, okay? There are a lot of rules. There are a lot of ways to do this. It is complicated, but it's really not that hard. And hopefully by the end of this, you will see that, okay? So Medicaid, number one, what is it? It is a support system that provides care for those who qualify. You will many times hear people say Medicaid is for poor people. It's not. You'll see as we go through this, you can get people with fairly substantial assets onto Medicaid legally, following the rules, and truly make a difference in people's lives. It is a federal system. Medicaid is federal, but it is implemented by each state with very different rules, using federal Medicaid law as a floor for qualification, okay? And what that means is there is federal law, each state was given that law, and then they submitted a state plan to say, okay, federal, here's how we're going to do it. And each state is given some leeway, and I obviously can't go through all of those, and I will point out particular situations where some things may be different in some states, but please go check your state rules because they will vary from state to state. For this presentation, I'm assuming that you have a basic understanding of Medicaid rules, and I am going to go through some very basics of the rules, but I wanted to focus on planning. And please understand, each of these slides, I could probably talk an hour on each one. So I am going through this quickly so that we can get everything into hopefully 45 minutes and have some time for questions at the end. But please understand, this is not a in-depth presentation, okay? So the Medicaid basics, everything a person has is either income or assets. When you sit down with a client and look at their situation, your first job is to say, is this income or assets? And that determination sometimes is not as easy as to figure out as you would think. It's like, well, okay, this seems like this, but it could actually be something else. So an asset is anything that a person has owned for more than 30 days, all right? Income is something that has come to the person and they have owned it for less than 30 days. So when income comes in, if a chunk of money comes in during the first 30 days, typically it is considered income. If they don't spend it during those 30 days, it then becomes an asset. Now, here's some confusing examples that we come across all the time. So a annuity, you may look at it and your client may see it as a annual pay or a monthly or annual payment that is coming in. It's like, that's income. However, there are some annuities that are income, but there are some annuities that are still an asset. And it basically boils down to, can you cash in that annuity? If you can cash it in, it is generally going to be an asset. If you cannot cash it in and only get income, then it's income. When you're looking at an IRA that is paying out required minimum distributions, many times people look at that, it's like, well, every year I get a check from that, so therefore that check is income. Well, it's actually not. It is depleting the IRA, which is an asset. So when they get their RMD, it is depleting the IRA. They're just taking it from the IRA, putting it into their checking account. That is not income. It is an asset that you've pulled from somewhere else. And finally, the bane of my practice is oil and gas royalties. And I am licensed in Oklahoma, and it seems like every client has oil and gas royalties, and they can be extremely confusing. As a general rule, if you don't own the property in which you're getting oil and gas royalties from, then it's income. If you do own the property and it is producing oil and gas royalties, there is some factor in the states I work in, it is 5 times the annual payment is added asset. Okay, so you can look at oil and gas royalties and see them coming in, but you have to look further to see, do they own the property that's producing this royalty or do they not? And your rules will then tell you possibly how to treat those differently. All right, very confusing and frustrating sometimes. Okay, very basic. So assets, when we have assets, there are assets known as non-countable assets. That's your home up to $603,000. Some states have higher limit than that. I think it's almost $1 million of a home can be considered a non-countable asset. Anything that is in the house, in the attic, in the garage, in a storage unit, household furnishings are not considered countable assets either. One vehicle, and you get to choose, and you choose the one with the most equity, not the most expensive one if it has a lien against it, but you pick the one with the most equity. That can be considered your non-countable asset. And then a irrevocable burial plan. So any plan out there that you have, that they have paid for and the contract is irrevocable, that the amount of money in that plan is not counted. And then the asset that sometimes causes us problems is a inaccessible asset, and that over 22 years of practice, I have only seen one bank account classified as a inaccessible asset that absolutely required 2 signatures to get. Pretty much every bank account, if it is co-owned, one of those owners can cash out the entire amount. So therefore, it is 100% a countable asset to the applicant. Where you will see true inaccessible assets is with real estate. Look at your state rules to see how real estate can be owned for it to be classified as inaccessible. In my state, if real estate is owned joint ownership with rights of survivorship, that is an inaccessible asset. If the other co-owners refuse to sell, we can't get to it, so therefore it is not counted. However, if it is owned as tenants in common, for some reason, Arkansas says they can sell their portion of that, and therefore their percentage ownership of that property is a countable asset. So a quick planning rule there is we simply take tenants in common property and convert it to joint owners with rights of survivorship, and it instantly goes from a countable asset to a non-countable asset. And in some states, the IRA of the community spouse will not be counted. The best way to know that is to go to the ASHPR website and click on your state's page, and Amber does a fantastic job of telling you which states do that and which states don't. Okay. And then the countable assets are basically everything else. All right. Pretty easy there. Let's talk about income real quick. Income that comes to a person and they have had for less than 30 days. Typical income, Social Security, pensions, oil and gas royalties, if it fits like I've said before, and then payments from annuities that cannot be cashed in, that is income, okay? So there are two types of planning that we as elder law attorneys do. There is crisis planning, which is the client is in or a loved one is in a nursing home or will go to a nursing home very soon. It's like they are on their way, if not there already. That's crisis. It's like, oh my Lord, we're now spending $6, $8, $10, $12, $14,000 per month. We have assets, we need help. Pre-crisis is when the client is pretty sure that they have at least 5 years before needing to go into care. And you're planning for each of these are very different, but you need to understand both in order to do either one well. Step one of crisis planning. The first thing that you do is figure out where they are qualification-wise. There's a whole lot of folks come into my office and they have X number of dollars, and particularly if they're married, they can have $30,000. And I'm like, you're fine. Go to the nursing home, apply. You're under the asset limit. Everything's good. But your job as an elder law attorney, the first thing that you need to do is figure out why are they not qualifying. See what's keeping them from qualifying for Medicaid. There were mainly 3 reasons someone would not qualify for Medicaid at this point. Too many assets, too much in income, particularly if you're in an income cap state. And number 3, there has been gifting within the past 5 years. All right. So let's go through that. The second step is if you have too many assets, and let's talk about a single person first, it's simple. You just have to get them down below $2,000. That's known as spend down. How do you do that? Okay. First, look at things that this client needs. Even though they are going into a nursing home, they still need things such as clothes. So I tell my families, go to Walmart, go to, wherever they buy clothes and go buy them enough clothes for this season, next season, and buy some extras because nursing homes do lose clothes. They, things disappear all the time. Any medical equipment they may need, hearing aid, glasses, dentures, I recommend that you get a second pair of those because nursing homes are notorious for losing those things, okay? And so if they are very dependent on glasses, go buy another set of glasses or 2 sets of glasses just to make sure they always have glasses. If they are very dependent and need their hearing aids, they're probably going to get lost. Go buy some new ones, okay? Any supplies. Typically, nursing homes don't supply good Depends, the diapers, shall we call it. They're rough, they're just not good. And so I tell my families, go buy as many packets of the really good Depends that you can store at your house and pay for those. Those are perfectly acceptable by Medicaid. In any other supplies, Kleenex, toothpaste, things like that, go get this person set up. I would suggest paying off any debt because those debt collectors will get ugly. You can say, look, they're broke, they're in a nursing home, you're not going to get any money, but they will just continue to hound the clients. And so generally it's way down the list, but I do recommend that you pay off debt. And the burial, make sure they have their burial paid for, make sure it's irrevocable and done. Then finally, once we've done all of those things, if we have any other money left over, we then consider gifting. Okay, planning with gifting. So when I say planning with gifting, I'm saying we do the gifting now. Okay, the client who is the single client in the nursing home, they rarely do that, but there are times that they could. They can say, I want to give money to my kids, my grandkids, or whatever. Typically, though, it is the agent under a power of attorney who is going to follow your advice and do gifting in order to get this person qualified. Understand, one of the pre-crisis things that you need to do is estate planning, and the power of attorney, the agent under the power of attorney has to have authorizing language in the power of attorney to do gifting. Okay. It is, and there have been times people have brought into me a power of attorney that disallowed gifting, and we were unable to do gifting, and therefore all of their money went to the nursing home. It was a horrible meeting, sad. I mean, there was one beneficiary, she was the agent, and I could have saved half, which I'll show you in just a second, but we could have saved a large sum of money, but we couldn't because the POA prohibited gifting above the annual exclusion. And so make sure that when you're doing powers of attorney up front, make sure you have unlimited gifting and that the agent themselves can make gifts to themselves. You have to know the gifting rules. This is absolutely the planning tool for large single estates is you give it away, all right? And so there is a 5-year look back. I'm sure that you know that. And there is a formula. Amber knows this formula. She can help you. I have just this morning, I was going through this presentation and I have sent off to a graphic designer my interpretation of the formula, how to use it, how to check your work. And so check with me. I will give you my email address later, and I will send you this PDF that talks about the gifting formula. I call it the golden formula because if you know this, it is gold because it helps the family, save some money, and it's good for you because people will hire you to implement this formula and save them money. That formula will be able to let you tell the family exactly how much money you're going to be able to save them. That they come in with $200,000, going through this formula with their cost of care and their income, you can say, I can save you $114,563. It's like, how do you know that? Well, I just know, okay? This formula tells me exactly how much I can save you, and they will hire you if you can do this. It was about a year ago that I did a full presentation for Amber on exempt gifts. Okay. If you want that presentation, email me at the email that I'll show you at the end of the presentation. Please email me and I will get you that information. But here's a quick summary. These are awesome tools. If you know that you can actually give things away without a penalty, absolutely do it. And it's a surprise to the families. And they're like, oh my God, I get the house? Yes, you do. So spouse to spouse transfers, why would we do that? Okay, number one, you transfer the house from being jointly owned between both spouses to being owned only by the community spouse. So if that community spouse passes away, then the house is not in the name of the institutionalized spouse, and therefore Medicaid can put a lien on it. And so if your state will allow you to just put the name in the name of the community spouse, and then the community spouse either does a deed that instantly transfers that property to the heirs at their death, or you do a last will and testament that has a special needs trust for the minimal amount that the state requires to go back, but it is not the full value of the house. It is what is absolutely required. Thankfully, I live in a state where I can do a deed from the community spouse to the kids, and it goes with nothing going back to the institutionalized spouse. So that's why you want to transfer the house from being jointly owned to just being owned by one spouse, and that transfer is not penalized. If there is a disabled child, you can actually give the home to a disabled child with no penalties. And these are meetings where you're going through it. I always ask about the children, tell me about the kids, and I just randomly say, are any of the children disabled? Yeah, we have one disabled daughter. Okay. And they're wanting to protect assets. I'm like, this is going to be easy. Okay. I charge for it and I don't give up the farm until we're at the end and I say, look, I can protect the entire house. Well, the nursing home said we would have to sell it and use the money to pay for the nursing home. I know that's what the nursing home said, but it's not true. We can actually, and once they say, yes, we will hire you, yes, we will let you do this application, I say, here's how we do it. The disabled daughter gets the home, no penalty. And they're like, this is fantastic. Okay. A interesting rule that if I call this the old maid rule because I've typically seen it where two sisters never got married, grew old together, living in the same house. They both paid in on this house, and now one of those sisters needs to go to the nursing home. We can actually deed her interest to the sister that is not in the nursing home. And as long as each of them paid in on this house and they do have a equity interest, you can actually give that interest to the other one so that the non-institutionalized sibling is the sole owner without a penalty. And then absolutely one of the exemptions that we use frequently, and it's fantastic, is the caregiver child exemption. So if a child moves into the home of the parent and provides care for them for at least 2 years, and that care typically kept them out of a nursing home, you can now give that house to that child without a penalty. And so particularly in your pre-planning meetings, this is a great way for, to keep mom out of the nursing home, which is what everybody wants, but no one really wants to move in with mom typically. But if it's like, hey, if you do, we can give you this house, they're like, absolutely, that's fantastic. So you sometimes see it pre-planning, but when you see it in a crisis planning where that person's in the nursing home and the child has lived there for more than 2 years, boom, the house is protected. So that was the home. Any asset, though, can be given to the spouse. No penalty with transfers between spouses. Again, you can give anything to a disabled child. And by the way, a child is deemed disabled, particularly if they have Social Security disability. If they don't have Social Security disability, most states have a way of determining that a person is disabled. They'll send out a nurse or whatever and be able to determine that that person is disabled without being on Social Security disability. You can actually make a transfer to anyone with a disability, and you typically do that with a trust, and that is a sole benefit, typically a special needs trust. All right, so now we move on to a married couple. It's a little more complicated, but it's very beneficial. This spouse is coming into you thinking that they are going to lose everything because the nursing home told them that, and particularly Betty down at the beauty shop said, oh, your husband's going into the nursing home, you're going to lose everything because I know Joyce was in here last week and that's what happened to her. And so your client comes in scared to death thinking she's going to lose everything. So with a married couple, we have to determine a snapshot amount. And the snapshot date is the first day of 30 days in a long-term care facility or when someone applies for Medicaid under a waiver program. So it's not after 30 days, it's the first day, but they have to be there 30 days for us to have a first day. All right. On that date, you look at all of the assets, pull out the non-countable assets, and then you have the countable assets. Of the countable assets, each spouse gets half up to the maximum CSRA, the Community Spouse Resource Allowance. That changes every year. This year it's 128 and some change. And with the 128 that they get to keep, everything else goes over to the other spouse if you're more than twice that. If you're at $200,000, each spouse gets $100,000. But if you're at $300,000, one spouse gets 128, the rest of it, 172,000, goes over to the other spouse. Okay, so the maximum CSRA is the max that the community spouse gets to keep. Once we know that number, and once we've done the split, we now spend down of the institutionalized spouse's amount to get them down below $2,000. You can spend it on the same thing that I've talked about spending it on the single person, supplies, medical equipment, things like that. In most states, you can also pay for the burial of both spouses. They will allow you to use institutionalized spouse money to buy the burial plan of the community spouse. It is good, and I highly encourage to spend money on the home. Now, why did I not mention that for the single person? This is a huge point of contention with a whole lot of clients. They're like, but wait, my dad's single, he can own a home and still qualify for Medicaid. Yeah, that's true. But what people don't tell you, and if you read the fine print on your Medicaid application, is Medicaid can put a lien on that property and get their money back. So typically for a single person, I want them totally broke. I want them totally under $2,000. And that's where that gifting formula, the golden formula, comes in to get rid of the house and get rid of the money and truly get them down below $2,000. Because for a single person, their income goes to the nursing home. You can own a house, but you can't pay for it. And so the family ends up paying for it, the taxes and insurance and upkeep and all of that, only to learn at their death that Medicaid steps in and they get their money back. So get rid of the home on the single person almost always, but for the married person, you still have someone living in the house, and therefore it's a great way to spend money. To spend down is to get the house paid off, pay off the mortgage, or replace the heat and air, window, siding, flooring, carpet, all of those things, household furnishings, buy a new refrigerator, buy a new washer and dryer, whatever needs to be done, do it. Now's the time to do it, because we've got to spend this money somewhere, and we've got to spend it fast, because if we don't spend it fast, we're still paying for the nursing home. And then the last thing that you do, once you've paid off the car, paid off the house, bought everything that you need to do, it's like we still have X number of dollars we need to do something with. That is where you look at the Medicaid compliant annuity. That's what Amber talked about before, and that's what she is fantastic at. And I will say Ashper is the best at doing that. So you do everything else spend down wise, and then at the end say, okay, we've got this much money, call Amber, she'll take care of it for you. Now, third step is we have to look at income. So as long as the income is below the cost of care, you need Medicaid, okay? There's that gap there that requires you to need Medicaid to pay for care. However, even if the institutionalized person's income is over the cost of care and they're married, you have to look at the married person's MMMNA, minimum monthly maintenance needs allowance, okay? If she's making $500 a month, but she's supposed to make $3,200 a month, we get to pull $2,700 a month from the institutionalized spouse and give to her so that she can survive. She gets what your state says she gets to have. And therefore, when you pull that money from the institutionalized spouse's income, that drops them below the cost of care, and they need to go on Medicaid. Some states are income cap states. And so if your state is a income cap state, they have said if the income is over, it's about $2,200 per month, then you're disqualified unless you put at least the excess income into a irrevocable income only trust, also known as a Miller trust. Okay. And like I said, I could spend probably 2 hours on that topic alone because there are confusing things about it. There are steps in it that you have to be very, very careful with. There's your crisis case. Okay. Once you determine, figure out why they are disqualified, too many assets, too much income, figure that out. Fix the assets with spin down. And I just went through what typically is allowed for spin down. You tell the client, here's where you can spend your money. Do any of these appeal to you? And particularly if there's a mortgage, many times with a married couple, you pay off the mortgage and boom, they are spent down. The house is paid for. The other spouse gets to keep all of that money and it's done. Fix the income with transfers to the community spouse to meet the MMMNA, or if they're single or married, but their income is too high, you have to do a Miller trust. Please understand, gifting is a great tool if you know the golden formula, because particularly with a single person, they come in, dad has $200,000 and we've been told he'll lose everything. But you go through this formula and say, well, if we do this, if we do the gifting, and if the agent, the power of attorney allows the agent to do it, we can protect. It's almost always half, and many times it's above half. And they are surprised and very happy that you can do that. So see, it's not hard. It's, here's what's causing them to be disqualified, here's spin down. It's not that hard, but it is complicated because there's steps, there's timing, there's things that you may think make sense, but really don't make sense, okay? Let's talk about pre-crisis real quick. Pre-crisis is, I think, sometimes easier, and it's not running around with your hair on fire trying to gather all these documents because we're paying $7,000 or $8,000 per month. It's like, with pre-crisis, you can take a deep breath and say, okay, look, I think what surprises most people, and I do a coaching course, and I coach attorneys across the country on how to do this. And they are surprised when I say, essentially, every estate planning client should be considered a pre-crisis Medicaid client. And if you're only doing estate planning, if you just got started, your clients are going to get older and they will probably call you back and say, hey, you did a estate plan for my husband and I, and he is now in the nursing home. Now what? Okay, well, you are going to become either a Medicaid attorney or you're going to have to refer those folks out. I encourage you to do estate planning, but consider every estate planning client as a pre-crisis client. You have to have powers of attorney in place, and please do the very comprehensive powers of attorney. One thing that needs to be there is unlimited gifting. Another handout that I will get to you if you ask me is a handout that I call the 9 powers that need to be in your power of attorney. And I go through 9 different things that over the years I have learned that I have seen lacking in non-elder law powers of attorney that should be in your power of attorney. And it's a document both for the clients, but I tell the client, take this to your attorney and make sure that they do those. So if you'll email me after the presentation, I will get those to you. During the meeting sometime, and I typically do it at the signing, if it doesn't just naturally come up in the initial meeting when we are talking about estate planning and backing up prior to death to say, okay, here's why you need powers of attorney. Sometimes it'll come up then, but it definitely comes up in the meeting where we sign documents. I say, look, your power of attorney is much longer than anyone else's that you'll see unless they came to me. The reason for that is there is language in here that may scare you at this point, but it gives your agent the power to save your entire estate once you need nursing home care. And they're like, what? I thought I had to be broke. Well, you typically do, but I can help you not do that. I can help your agent make sure this doesn't happen. And so that automatically opens up the entire conversation about long-term care and how we can protect that. And we've done these documents in light of that. So please come back and see me once you need long-term care. After 20 years of practice, I would say probably at least a third of my new crisis clients are clients that I have done estate planning in the past. It's been enough years now. They need help and they come and see me. All right. At least introduce them, bring it up to say, look, if you really want to protect your assets, the revocable living trust does not protect your assets from Medicaid, but I do have a trust that will, and it's an irrevocable asset protection trust. That trust is kind of scary. You do lose control and benefits, but it does protect your assets from Medicaid and will get both of you, both spouses, much closer to qualifying for Medicaid than if you don't do it, okay? So, tips for presenting this to the client, okay? So many times my coaching clients are like, how do I present this? There's so much out there. How much do I give them? How much do I not give them? Do you have ways to do this? And I've trained in person in my office, probably half a dozen to 10 attorneys. The first thing that I almost always see is the attorney wants to prove how smart they are to the client, and they start talking all these terms and procedures. I'm like, stop it, okay? Clients don't care how smart you are. What's interesting about this generation is they respect a law license. They know you've been to college. They know that you've gone through a test. They respect you because you're an attorney. They automatically think you're smart, okay? The more you talk, the more you try to do stuff, you're just going to screw it up, okay? You may say something that lets them know it's like, this person's not that smart. Had you just kept your mouth shut and just solved their problems, which I'm about to talk about, is just solve their problem. Okay, let's just do it. Clients pay money for solutions. They don't pay you because you're smart. They pay you because you can solve a problem. They come in here thinking they're going to lose everything, and you're able to protect, for a single person, half or more than half, and for a married person, almost always everything. Okay, they want a solution, and that's what they will hire you for. So show them the solution. Solve their problem. Okay, good. Give them just enough information to let them know that you know what you're talking about and you have a solution for their problem, and here it is, and you need to hire me to get that. Show them how much money you can save them and still follow the Medicaid rules. I always love it as we go through this. I'm like, see, you don't have to spend anything. They're like, is that legal? I'm like, oh my Lord, yes, it's legal. I am following the rules. I promise you. I love my law license and I don't want to go to prison. And so, yes, this is legal. I've been doing it for years and it works. Okay. And another early thing that I see people do is they give away the farm. There's been some, this is complicated enough. Most people, even if you did give them everything, they're like, oh my Lord, I can't do this. Yes, I will hire you to do it. But there are some people, particularly engineers, that if you give them too much information, they'll say, okay, I got this, and they'll go try to do it themselves. So you want to show that you can solve the problem and save them money and not give up too much, but give up enough so that they know that. It's a fine line, and it truly does take experience or feedback, and that's what I do that for my coaching folks. It's like, okay, you're going way over the line, or you need to give a little bit more. I can't tell you exactly how to do it, just do it, okay? Pricing. I'm pretty sure that you're not charging enough. When I meet with new coaching folks, I'm like, you're only charging that and you're spending this many hours. I promise you, you can get more money for this. Medicaid planning pricing should be connected to the cost of care. That's the number that is sticking in their head, okay? Mom's in the nursing home and it's costing $10,000 per month. In your meeting with them, you need to bring out that number as many times as you can without just being obnoxious about it or going over the top. Keep saying $10,000, $10,000. Anytime it's appropriate to say, yeah, you're going to spend $10,000 per month on this or that or whatever. Yes, the nursing home costs $10,000. Just bring that up and get that into their heads so that they are thinking $10,000. Then your fee is then a factor of the monthly cost of care. It just makes sense. So for a married couple, they come in thinking they're going to lose at least half, if not everything. And you say, look, without hiring me, what the nursing home told you is you've got to pay 38 months before you are down to where he now qualifies for Medicaid. But going through this spend down, we're going to pay off your house. We're going to get you a new car. We're going to pay off the credit card bills. We're going to get your burial paid for. You're going to spend money on things that directly benefit you. And with this annuity, you're going to get everything else. You're going to pay 0 months of nursing home care. So rather than pay 38, why don't you pay me 2 and I'll do it for you? And they're like, absolutely. There is no doubt in my mind that's worth it. For a single person, again, they come in thinking mom and dad are going to lose everything because everybody knows you got to get down below $2,000. You go through this formula. With this formula that my handout will show you, you can go in and say, I can protect exactly this much money, and that's after, excuse me, that is after my fee. So if you do it the way that I tell you on this handout, you take out your fee first, then run the numbers and say, look, you're going to keep out of $200,000 $114,600. And that's after my fee. Do they care what your fee is if you've taken them from $0 protected to $114,000? They don't care what your fee is. So you build that in and do it, and they will hire you and they will pay you. All right, let's talk about this real quick. The cornerstone of the pre-planning is the irrevocable trust. This is a trust where the client does not benefit from the trust, and that's what scares them. They're like, oh no. Well, number one, don't put everything in the trust, but do put real estate and most of their assets. Keep out enough that they feel comfortable. My recommendation, and there are attorneys who disagree with me on this, but I come from a state that is very particular, and if there's any way they can make this trust a countable asset, they're going to. I don't let my clients be the trustee of the trust, okay? Just to be safe. And so selling this trust is not easy. You should charge probably twice what you charge for a revocable trust, if not 3 times. Again, related to the cost of care for 1 month's worth of nursing home care, this trust will protect you from many months of nursing home care. The key thing here is you say, look, we've got 2 government agencies. Medicaid says you need to be broke. IRS says you need to still hold on to things to get tax benefits. This trust does both, okay? Again, that's a 1-hour presentation within itself, but just please understand the cornerstone of pre-planning is the Irrevocable Asset Protection Trust, and you should charge 2 or 3 times what you charge for a revocable living trust. All right, this trust protects everything that's in the trust if you can make it 5 years, and it's just a beautiful tool, and particularly for the married client who is getting a large amount of assets. The community spouse gets those. Now what? When they need nursing home care, we're now down to a single person and we can protect half. With this trust, if they'll put everything in there, we can protect way more than half and get them very close to qualified. Okay? I have flown through this. If you want more, okay, on June 4th, 2021, from 9 until 4:30, I am doing a Medicaid boot camp. It is virtual, it's Zoom, and it is my goal, okay, a lot of you have probably been to or you've seen advertisements for, there are some weekend programs out there that you go for probably Thursday, Friday, Saturday, and it's 3 days and they give you some Medicaid training, I think I can do all of that in 1 day. Okay. So during this from 9 to 4:30, June 4th, 6 hours of education, I'm doing my best. I've taught those weekend programs before, and I'm going to put all of that into 1 day. I've applied for continuing legal education from Arkansas, which I think if one state does it, the other state should do it. And I will let you know on that, but I've applied. My goal is to get a weekend's worth of Medicaid training and a little bit of office management into 1 day. I think I can do it. All right. I'm charging $149. Okay. For 6 hours of education, that's half of probably what you need for the year for $149, and you can sit at home. Okay. If you're interested in that, my coaching website is elderlawinnerbox.com/bootcamp, and that will give you all of the information. And my email address, I just remembered, I don't think I put that in there, but Trisha is doing it in the comments, is Todd, T-O-D-D, at elderlawinnerbox.com. You can send me an email or Trisha an email. All right, questions. 11:46, Amber. I told you I'd be close. Okay.
Mhm.
All right, questions. Come on, I know. I went through that and there's got to be some questions.
There is a question here about how attorneys can become coaching clients of yours.
Okay, go to elderlawinnerbox.com and there is information there, or just email me or Trisha.
There's a question related to whether the boot camp will work or be relevant for Florida attorneys.
Yes. I have a few coaching clients, none now. I've had a coaching client in Florida. It is different, but yes, it will. It's federal, but I will determine, certain things that some states require.
Okay, and then there's a question about where can I find a copy of the presentation materials? I'm assuming if she emails Trisha, she can get a copy of those.
Absolutely.
Okay, perfect.
All right. Question is, client is 62, placed in a nursing home 3 months ago. He has rental property, no gifting in the POA. Ugh. Go to the client and see if there's any way they can basically understand that they need to get rid of that property, draft the deed, see if the client will sign it, and get that out of their name. Okay. Get it to a kid or somebody, list it, sell it, and then use the formula that I've talked about to protect a good portion of the money. Or you can actually, if the person still has capacity, I've actually do a elder law specific power of attorney, and that'll solve a lot of problems, because now you've got a power of attorney that will let the agent do all kinds of things rather than just do a deed. So, typically the mental capacity is not quite as high to just sign a deed. No one questions that much. So if you can only do the deed, do the deed. But if you can get a power of attorney, a elder law specific power of attorney with gifting language, I would highly recommend that.
Okay, and then another question here is to tell them more about what they would get with the coaching program.
Sure. So the coaching program, there is no contract. Okay, you can leave any time that you want to, but I have designed it basically for a year, because having trained numerous attorneys, they get overwhelmed very quickly. And so I have designed this so it's 12 months. Again, there is no contract. You can quit anytime, but basically each month is a 1.5 to 2 hour recorded educational event. So like the first 3 months is Medicaid. So I spend 6 hours and I go into more depth than I can go into with the boot camp, because there's breaks and different things. This goes into extreme detail. Is the training each month is 1.5 to 2 hours recorded. Then we do a live Q&A with all of the coaching folks. They come together and you ask questions about the training or just questions in general. What I think is most important and what all of the coaching folks have said, this is worth the price of admission, is we do at least 2 45-minute to 1 hour one-on-one phone calls. So I am on the phone with you. If you'll send me your questions beforehand, I'll look over them. We go through those. I've done just answering questions. I've done client meetings with people so they can see how I do the presentation, how I address objections to a power of attorney or the irrevocable trust, whatever. Help them through the meeting, help them sell a client that they've had a hard time selling. You name it, those 2-hour phone calls are whatever that you need from me. And it's fun because I've got one coaching client who is a CELA. And so that's a very high level discussion. And I've got a few folks who have just come out of corporate and they are just opening the doors, still working from home. And, that's a very basic, okay, remember, countable assets are this, non-countable are this. Look at the Miller Trust, it's very basic stuff, but it's getting them up and going. And so we do 3 months of Medicaid, 2 months on VA, 1 month on estate planning, 1 month on marketing, 1 month on the initial meeting. How do you do a meeting? How do you address the clients? How do you sell this? Like I said, each of those slides I just went through, I could probably easily spend an hour. Okay. All property is in the client's revocable living trust. Okay, well, that's great. So the trustee, if the client in the nursing home is incapacitated, then the trust probably allows the trustee to do something. And I would read that thing and do my best to, determine. Keeping it in the trust is not for the trust benefit because they will lose everything. Okay, so the client is deemed incapacitated and cannot execute. Okay, so you may be stuck. Okay, if they truly are incapacitated and the POA does not let you do it, that was that case I just mentioned. $300,000, I was going to be able to protect $150,000 plus some, and the POA had no gifting language and actually prohibited gifting, and I told her there was nothing I could do for you. Okay, so you can't do gifting for married couples. You can, but I just don't see that it's helpful because we can get the person qualified immediately using those spousal rules. We can get everything to the community spouse quickly and get that person on Medicaid and get Medicaid paying, and the family doesn't pay almost immediately. So therefore, rarely do I do gifting with married couples, but you can. Sometimes you'll see there's been gifting in the past, but you still treat it through that formula that I've talked about, and just you only have to suffer half of the gift rather than the entire gift. Let's go back. Disability trustee will be selling. Okay, good. Do you ever do a limited conservatorship guardianship if the POA is defective? Sure, that is your only option. The 2 states that I've worked in, Arkansas and Oklahoma, the judges have been very, very resistant to let us do Medicaid planning under a guardianship. I think that violates all kinds of constitutional and different rules, but so far I've had very little success gifting under a guardianship. But if you think your state can do it, if you think you can convince the judge to do it, absolutely, that's what I would do. Do non-income cap states allow something like a Miller Trust? Well, you don't need one because typically the person in the nursing home, their income goes to pay for their care. And so there's no need for the income trust. Okay, can a non-attorney take the coaching class? Never been asked that. Let's talk about that. Whoever sent that question, let's see why and who you work with and yeah, let's talk about that. That's interesting. Have you ever done POA modification with clerk of the court to allow gifting that otherwise is silent or limited to gift tax and exclusion? No. Apparently, in our POAs are typically not recorded. They don't have to be recorded, and so if yours are being recorded and you have to go through the clerk of the court, I am completely unfamiliar with that process, but I'll be glad to look at it and figure that out. But that's something we don't do in the 2 states that I work in. Those are great questions, by the way. Did I miss anything, Tricia? I do encourage you, go to elderlawinabox.com and you should get all the information there. What is the legal basis that protects the home from estate recovery when the IS deeds the home to the community spouse who then executes? The legal basis is she, let's say she is the one in the nursing home. And so she signs a deed giving it to her spouse. And now the spouse, that gets rid of dower, courtesy, all of that stuff. He now owns it. And in my state, they have not forced the spousal share at death. And so therefore he can do a beneficiary deed to the children. And at his death, his interest, which is the whole interest, since she gave up her interest, now goes to the kids. And so far the state has not questioned that. Okay, the office management, we will talk quickly. I don't want to spend a ton of time on office management. We can talk about that afterwards, but the office management part is dealing with a new concept that I am implementing in my office, and it is known as the lawyerless first meeting, meaning that the first meeting with a client is not with an attorney. It is with a office person that has been trained to look at issues, not give legal advice, but just gather information. We've had a horrible time of getting clients to fill out their intake sheets. And so people walk in and they spend the first 15, 20 minutes of their free 1-hour consultation giving us information. And it's frustrating, it's aggravating. And I found myself wasting a whole lot of time on clients who did not do their part. And so now they're going to meet with a person who will get that information, determine if they need to see me, and kind of be a gatekeeper to do that. But then that helps free up my case manager, who is my Medicaid application person. And I will talk about how I get clients to rely on her, trust her, they email her, not me, and it sure makes life easier. So yes, I will talk about that some. All right.
Perfect. Thank you, Todd. And I'll also mention that the May webinar is also going to be done by Todd. He's going to be talking about essentials to building your elder law practice. So that's going to be on May 19th at the same time, 12 o'clock Eastern. If you have any questions for myself or for Todd, feel free to reach out to either one of us directly. Thanks again, and thank you, Todd. Great presentation.
Thank you. Have a good day.